So, the legal effect, when we consider the legal effects, there are two legal effects of the certificate of incorporation. One is with regard to the organization. Now, the company was actually incorporated on 10th of January. That is the actual date. But erroneously, certificate says the company was incorporated on 5th of January. Right? Then what happened in this case, that the person argued on 5th of January, there was no company by this name. Therefore, this company cannot issue shares because on 5th of January, the company is not incorporated. Therefore, there is no such person by this name, no legal person, no company by this name on 5th of January. Therefore, the company cannot issue shares on 5th of January. But court here, with the date mentioned in the certificate of incorporation as 5th of January, date of incorporation is 5th of January, then that is the date of incorporation of the company. Nobody can challenge that. Right? Nobody can say, no, actual date is 10th of January, therefore on 5th of January, this company is not available to issue shares. Likewise, nobody can challenge. That is the meaning of conclusive evidence. Right? Irrebuttable evidence, nobody can challenge these two things. Right? One is with regard to the steps. Right? All steps are taken by the company and date of, yes. The date mentioned on the certificate is treated as the date on which the company came to exist. That is the date of birth of the company. Is the list. Right. So we can explain the legal effect of the certificate of incorporation. Right. Tell me, take down, right? Right. Right. The certificate of incorporation. The certificate of incorporation has two legal effects. Has two legal effects. Right. Number one. Right, under the application, right, number one. Right. The company has taken all necessary steps in order to incorporate under the company's name. Under the company's name. Right? And under that, you can say, therefore, even if a particular step is not taken, in the process of incorporation. It does not invalidate the incorporation. Does not invalidate the corporation. Right? Other past paper, it says application form or Form 80 is not signed by particular director. Therefore, the other party argued that the company is not properly incorporated. Right? Right? Nobody can challenge. Only thing is we have to consider whether the certificate is issued to the company or not. For example, that we can say example, like one example we can mention, particular step is not taken for that. We can mention this example, right? Example, for example, like Form 80 is not signed by Form 80 is not signed by the director of the company. Director of the company. It will be signed, right? It will be signed. It will be signed by all the initial directors. But right, the director did not sign this Form 80. But only the certificate is issued, then we can challenge that. Because of this reason, incorporation is in there. Right. Then number two, the second legal effect. Right. Number two, the company came to an existence. Right. The company came to an existence on the date. On the date. On the date. That is mentioned in the certificate. That is mentioned in the certificate of incorporation. That is mentioned in the certificate of incorporation. Then next line we can say these are treated as conclusive evidence. Conclusive evidence. Conclusive evidence. Right. Therefore, nobody can challenge. Challenge these facts. These facts. Challenge these facts. Right. So that is the legal effect of certificate of incorporation. It creates two conclusive evidence. It creates two conclusive evidence. One is with regard to the steps. All the steps are taken. Company came to an existence of the day which is mentioned in the right certificate. Right. That is the legal effect. Right. We can move on to the part B of the question number 1. LMN Private Limited owned by Mr. D. Silva and this is wholesale. Right. Defaulted on a large loan obtained from a finance company. The directors had meanwhile diverted company funds into their personal bank account. Element Private Limited owned by Mr. D. Silva and this is Fonseca defaulted on a large loan obtained from a finance company. The directors had meanwhile diverted company funds into their personal bank account. The finance company seeks to hold them personally liable by requesting the court to lift the mobile claim. Right. Right. So here the company, they are the owners. Mr. and Mr. Silva and Mrs. Fonseca. And not only that, defaulted on a large loan obtained from a finance company. Then thereafter, they diverted company funds into their personal bank accounts. Right? This is the issue. Personal bank accounts. The finance company seeks to hold them, right? Hold their personal liable. That means directors' personal liable by requesting the court to lift the corporate way. Right? So this is with regard to the corporate way of incorporation. Right? Explain the principle of separate legal personnel. Right? Very simple. Right? What is the meaning of separate legal personnel? For corporate way, it is named as corporate way. Yes, what is it? 5 marks here. Corporate way. First time in the legal history, this concept is recognized in Solomon versus Solomon Company Limited case. What is the meaning of this? What is the meaning of separate legal personality or corporate way? Yes, remember. Because of the corporate way, right? The third party cannot see beyond the company. Because of the way, third party can see only the company. Therefore, third party cannot see directors, owners, employers of the company, right? Employees of the company, officers of the company, right? So that is the yes. That is the result of the corporate page. So what is the corporate page? Corporate page. So because of corporate page, cannot see, right? Third party can see only the company, cannot see like shareholders, directors, and officers of the company. Yeah. Right? Corporate page, right? Corporate page. 5 marks given the right. Corporate page, right? After incorporation, right? After incorporation of the company, after incorporation of the company, after incorporation of the company, it is treated as separate person. Is treated as a separate person from those who create it. Those who create it. Right. Right. The persons who are creating the company is named as this. What is the name? What is the name we can give? Those who create it. Within brackets, we can say promoters. Promoters. Those who create it, right? We name them as promoters. Promoter is the person who is taking necessary steps in order to incorporate the company, right? Promoters. Right? Come on. Right? Those who manage it. Those who manage it. Right? Those who manage it. Right? Who are managing the company. Right? Within brackets, we can say directors and employees or officers, like accountant, right? Lawyer, right? Secretary, right? So they are the officers or employees, right? Close bracket. Those who manage it and those who own it. Those who own, right? Who are the owners of the company, right? Within brackets, we can say members. We can say shareholder. Shareholder. Then next line we can say, right? Next line. Therefore, for the activities of the company, the company. Suppose the company itself responsible. The company itself responsible. Yeah, responsible. So this is the concept called separate legal person. For the activities of the company itself responsible. Right. Right. So in other words, we can say corporate veil. Because of the veil, third party cannot see beyond the veil. Right? Therefore, company itself responsible. Right? For the activities of the company. Right? Then we can move on to the second. Right? Second question. That is, identify circumstances where separate legal personality may be disregarded under the Companies Act and case law principles. Right? Identify circumstances where a separate legal personality may be disregarded. Right? Disregarded means we need not to consider about separate legal personality concept. Right? Under Companies Act and case law principles. Right? It is with regard to the disregard means lifting of veil of incorporation. Lifting of corporate veil. Right? Disregarding means making shareholders, directors, officers of the company responsible for the activities of the company. Right? So that is named as disregard the separate legal person or lifting of veil of incorporation. Right? Shall we take down? Right? Number 2. Right? Right? What it is, right? If the separate legal personality, the separate legal personality concept the separate legal personality concept is disregarded. Disregarded. The promoters, directors, officers, and members of the company officers and members of the company personally responsible for the activities of the company. For the activities of the company. Right? This slide we can say this is named as lifting of corporate veil. This is named as lifting of corporate veil. can consider two categories. We can link the vein of incorporation under the Companies Act according to case law principles. Right? You can divide right under Companies Act. One column we can right. This column we can mention under the Companies Act. Second column we can name it as according to case law. According to case law. Right? Right. What are the available? Shall we go to next slide? Right? As a heading, we can mention lifting of veil of incorporation. Right? Lifting of veil of incorporation under the Companies Act. Under the Companies Act. Evolution. So, under the Companies Act. Right? Number one. After that, we can say number one. Tell me, these are very important. Right? Tell me, what are the sections related to the Companies Act? We can link the veil of incorporation. Yes. First one is the section 2A, name of the company, right? I believe number one, name of the company. Section number one, you need to mention sections, right? The name of the company. Name of the company. And under that, we can say, right? If the name of the company, is not correctly mentioned on a document, name of the company is not correctly mentioned in a document, right? The document. Right? The person who has signed the document, is personally responsible right? When the company refers to accept the liability. Accept the liability on that document. That document. Right. Right. Name is erroneously mentioned, and the company refused to admit the liability. Then who is responsible? The person who has signed the document. Like a check, we can consider, right? Negotiable instrument, check. Name of the company is not correctly mentioned. If the company also refused to admit the liability, then the person who signed the check, right, as directors, right, director 1, 2, likewise, 1 loan, right, 4 persons, they have signed the check. Then if the company refused to accept the liability, then person who signed the check is person responsible. Right? That is the section 2A. Then there very important one is next one, that is insolvency of the number two, insolvency of the company. Over very famous insolvency. Right. We have discussed this one under duties of the directors also. Even under the duties of the directors, we have discussed this. Right. What is the insolvency? Under insolvency, right? How directors are responsible, person is responsible. What is the meaning of insolvency? Yes. Insolvency. No. Generally, insolvency means, right? Remember that insolvency means, right? Company unable to pay its debts in its ordinary course of business. Right? It refers to actually working capital. Working capital. Day-to-day business, company unable to pay its debts. Right? Right. On the face of the situation, we can identify the companies, right? Companies insolvent. Companies insolvent. And thereafter, we can consider, right? What are the assets, liabilities, and right ratio of the assets and liabilities. Right? On the face of the situation, we can consider that the company is insolvent. So, we want to pay debts. That's all. That is actually it is mentioned in this Companies Act. Right? Insolvency. Then what is the duty? Task of the director who came to know that the company unable to pay its debts. What is the duty task of the director? Yes. He must call immediately, right? No time, immediately, promptly, he must call board meeting. There are two meetings. One is board meeting, right? And second type of meeting is shareholders meeting, general meeting. Here, not a general meeting, board meeting to be called, directors meeting to be called. That is the duty, right? If not, then the director is personally responsible to compensate the same. Personally responsible. But I get right. Turning in the right. Insolvency of the company, right? Under that we can say, right? If a director, like if a director came to know that the company unable to pay its debts, that the company unable to pay its debts in its ordinary course of business, its day-to-day business or ordinary course of business, ordinary course of business, right? Then he must immediately call a director's meeting. Director's meeting or board meeting. You can say board meeting. Right? The director's meeting. Next line we can say, if he fails to do so, if he fails to do so, and as a result of that, as a result of that. If the company is liquidated, as a result of that, the company is liquidated, the director is personally responsible to compensate the creditors. Compensate the creditors. Under case law principles, shall we mention two examples, right? Next slide we can say, right? The case law principle. Case law principle. Right? Under that, we can identify two case laws. Right? The first one is very important, right? That is, right, number one, puppet company. Puppet company. Or we can say sham company. Puppet company. Or sham company. Right? Under that, we can say, right? If the company is incorporated to do an illegal act, is incorporated to do an illegal act, then the court can is the bail of incorporation. Court can is the bail of incorporation. Next slide we can say, according to the given case, the owners of the company right, diverted company funds into their personal bank accounts. Next slide we can say, this is an illegal legal act. illegal act. Therefore, it is an illegal act. Therefore, court can lift the corporate bail. Court can lift the corporate bail of L&M Private Limited. Corporate bail of L&M Private Limited, the company, right? L&M Private Limited, the company, right? To identify who are the owners of the company. Who are the owners of the company. Who are the owners of the company. Then another situation is national emergency. You can mention that one. Case law principle. Case law principle. Second example is national emergency. National emergency. Right. So these are the ways that the court can lift the bail of incorporation of the company. So first question is right on the incorporation and corporate bail. Right. Then we can go on to the second question. Right. Second one. Sunshine Limited incorporated to operate a chain of hotels. Used its funds to purchase shares in the software company. Sunshine Limited incorporated to operate as a chain of hotels. Used its funds to purchase shares in a software company. This decision was taken by the board against the articles of association and without informing shareholders. The investment caused financial profit. However, shareholders and creditors of the company now consider the validity of the decision. Right? Then the questions are defined an ultra-virus transaction. 3 marks given. Right? Then the second one it says why were such transactions originally void under common law? Right? And the third one it says, right, third question, that is, what are the legal effects of an ultra-virus transaction if the company incurs losses? So here there's a profit. If there is a loss, then what is the legal effect of an ultra-virus transaction? Right. 4 marks given. So altogether, yes, 10 marks given. Yes. Define an ultra-virus transaction. What is an ultra-virus transaction? Yes. That's right. So there are 2 types of transactions. One is within the objects, beyond the objects. Within the objects, intra-virus. Beyond the objects, ultra-virus transaction. Right. So ultra-virus means, right, ultra-virus transaction. Right. that we can say, right? These are the transactions. These are the transactions. These are the transactions. We own the objects. We own the objects of the company. We own the objects of the company. Right? Next time we can say, according to the common law, according to the common law, within brackets we can say case laws. Common law means case laws. According to the common law, these transactions, or ultra-virus transactions, are treated as void. 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 Next time we can say it means transactions are invalid. Transactions are invalid. These transactions are invalid from the beginning. From the beginning. From the beginning. Right? Then next time we can say, therefore, no party can see any relief on such ultra-virus transaction. Such ultra-virus transaction. So that is the ultra-virus transaction. Then why such transactions originally void under common law? Why? What is the reason? What is the reason why these transactions are treated as void according to common law? Yes. Why these are void? These transactions are treated as void. I have explained it. Yes. Very simple, right? Remember, right? Ultra-virus transactions are treated as void transactions according to the common law case laws. Reason is in order to protect shareholders and creditors, right? How they can protect by this rule shareholders and creditors, right? When we consider shareholders now, in the articles of association, company must mention their objects. Right? Now, suppose a person is going to invest in the shares of the company, prospective shareholder, future shareholder. Before investing in the shares of the company, he will consider what are the objects of the company, whether the objects are profitable or not. Right? Then after, right, get an assurance that the objects are profitable, then thereafter he will invest money in the company, right? Money in the shares of the company, right? Then thereafter, company must utilize the money only in that object. They cannot use that money for any other purpose. Understood? Therefore, what happens? The protection is given to the share investor. And the second one is protection given to the creditors. That is the second object. That is, now before granting a loan to the company, right, creditor must be satisfied whether the company has profitable business. How they can get that idea? By looking at the objects. Right? According to the objects, they be satisfied the company has a profitable business. Then grant the loan. And thereafter, the company must utilize or use the loan to promote its objects, not for any other purpose. Then what happens? Creditor, person who borrow lender, right? Then he can recover the loan, right? Loan with the relevant interest. That's why actually the protection is given to the creditor. Understood? That is the reason for this concept, ultra-virus transactions. They are treated as point for the commodity. Right? Shall we take them like this? Right? Why? Other such transactions originally going under the commodity. Right? We can say, right? Ultra-virus transactions are treated as void. As void under the common law. The common law, under the common law, to give some protection, give some protection to the shareholders and creditors. Give some protection to shareholders and creditors. Like 4 marks given there, right? The next line we can say that before investing in the company, before investing in the shares of the company, before investing in the shares of the company, before investing in the shares of the company, the prospective shareholders must be satisfied that the company has a profitable business. That the company has a profitable business. By looking at the objects of the company. objects of the company by looking at the objects of the company. The next slide we can say, therefore, after investing in the shares of the company, the company shall utilize the money only to promote its objects, only to promote its objects mentioned in the articles. Mentioned in the article. Next slide, we can say, right? Therefore, the protection protection is given to the protection is given to the money invested in the shares by the shareholders. By the shareholders. And number two, next slide we can say, right? Give some protection to creditors. Give some protection to creditors. Some protection to creditors. Under that we can say, before lending money to the company, the creditors must be satisfied that the company has a profitable business. By considering the objects. Right? Then next slide we can say, after receiving money, the company shall utilize the money only to promote its objects. Next slide we can say, right? Creditors can recover the loan along with the relevant interest. Along with the relevant interest. Next slide you can say. By this way, this rule will give some protection to the plaintiff. Will give some protection to the plaintiff. In other words, company cannot play out the money. They cannot like arbitrarily take a decision and use the money for different types of objects. They have to confine with the objects mentioned with the articles of association. That is the right. That is the way how it will protect the shareholders and creditors. Right? There are this is very important one. Number 3. What are the legal effects of an ultra-virus transaction if the company incurs losses? The company incurs losses. Right? Yes. What is your opinion? Legal effect of ultra-virus transaction. Now, this is according to the common law, right? According to case laws, ultra-virus transactions are void transactions. They are treated as void. Prohibited, in other words. Like no party can seek any relief on a void contract or ultra-virus transaction because in order to protect shareholders and creditors. Right? And the Companies Act, what is the position? Yes. Ultra-virus transactions are very important. Ultra-virus rule is recognized or eliminated, removed by the Companies Act. What do you think? I have explained that. But now, here, very important 2 sections. That is section 17.1 and section 17.2. Right? 17.1 says, if the objects now, when we consider section 30, right, with regard to the objects, the articles of association, right? Section 13 says the company may set out its objects. Therefore, setting out objects in the articles of association is not a mandatory requirement. Right? This up to the company. Company can mention its objects or company can avoid from mentioning its objects in the articles of association. Right? So if the 17.1 says if the objects are mentioned in the articles of association, then company and directors must engage into the contracts which are permitted or approved by the objects of the company. Right? In other words, actually, it has recognized the same concept, ultra-virus transaction, ultra-virus rule. Same concept, it is recognized under section 17.1. Then further, 17(2), right? 17 subsection 2 says, right, capacity and power of the company cannot be restricted by its object clause. Therefore, all the transactions means ultra vires or intra vires. All the transactions are valid and, right, enforceable. That is the provision, right? Section 17(2). Understood? There are two sections, right? 17(1) says, right, if the objects are mentioned in the articles of association, company and directors must confine their business activities according to the objects. In other words, they must, right, consider the ultra vires rule, right? Ultra vires rule is recognized. Then further it says, the subsection 2, 17 subsection 2 says, right, all the transactions are valid and enforceable. Valid and enforceable. It's mentioned like that. But further it says, however, before the company, now suppose the company is going to engage into an ultra vires transaction, then before engaging into the ultra vires transaction and after engaging into ultra vires transaction, right? That type of transaction has two legal effects. What are the legal effects? Right? What are the legal effects? Before engaging into ultra vires transaction, any shareholder or director can bring an action against the company to prevent the company from engaging into ultra vires transaction. Injunction, right? Bring an action in order to prevent the company from engaging into ultra vires transaction. That is before engaging into ultra vires transaction. The second, right, effect is, right, we have to consider after engaging into ultra vires transaction. So like this, after engaging into ultra vires transaction, nothing to prevent, right? So after engaging into ultra vires transaction, if the company suffers any loss, then who is responsible? Yes, who is responsible? Directors are personally responsible to compensate the harm. They are responsible to compensate the harm. Right? Now, what happened actually under the Companies Act, right? It says, right? Now, ultra vires transactions, right? This type of transactions have two legal effects. One is before engaging into ultra vires transaction. Before engaging into ultra vires transaction, any shareholder or director, right, can bring an action against the company to prevent the company from engaging into ultra vires transaction. First legal effect is shareholder creditor can stop the company from engaging into this ultra vires transaction. Right? Stop the company. However, suppose the company already engaged into ultra vires transaction, then thereafter nothing to stop. Right? Then what is the effect? Right? Then thereafter we have to consider after engaging into ultra vires transaction, by this transaction, whether the company gain a profit, right? Gain a profit or suffers a loss. We have to consider, right? What happened by this ultra vires transaction. If it is a gain, a profit, then it is not affected to the shareholders and creditors. Understood? Why this concept is recognized? In order to protect the shareholders and creditors. Right? If the company is able to earn profits, right, then it is not affected to shareholders and creditors. Therefore, it is okay. Right? The transaction, right, and with the profit. But if the company suffers or loss, then it is affected to shareholders and creditors. We have to protect them. We have to protect, right? For that purpose, this rule is introduced. We have to protect them. How we can protect? By this ultra vires transaction, company suffers a loss. Then how we can protect the shareholders and creditors? Right? Imposing the liability to the creditors, sorry, directors. Then it says if the company suffers, right, any loss, directors are personally responsible to compensate the company. Like they must pay damages to the company. Therefore, the company can recover the damages from the directors. Therefore, it is not affected to shareholders and creditors. Because company able to recover the damage from the directors. Therefore, it is not like affected to the shareholders and creditors. They are protected, right? By considering this concept and the provisions mentioned in the companies that the protection is given to the shareholders and creditors. But only the main thing is we have to protect the shareholders and creditors. Right? So, in order to protect, provisions are mentioned in the companies. Right? If it is a profit, it doesn't matter. It is not affected to shareholders and creditors. But if it is a loss, right? If the company suffers any loss by this ultra-virus transaction, then directors are personally responsible to compensate the company. Company can recover the money or loss from the directors. Therefore, right, it is not affected to shareholders and creditors. That is the way how Companies Act has balanced this situation, right? So it says actually it has recognized the ultra-virus rule, and there are things is right, right, the power and capacity cannot be restricted, right? All the transactions are valid. However, there are two legal effects. Before can stop the company from engaging into ultra-virus transaction. After engaging into ultra-virus transaction, which the company suffers any loss, then directors are responsible to pay. Right? Directors are responsible to compensate the in that way, right? Companies Act protect the shareholders and creditors. Protect. That is the way. Right. So here actually there is no any legal effect because this investment cost financial profit, right? Financial profit. It's okay. It is not like affected to the creditors and shareholders. But here the question is, what are the legal effects of an ultra-virus transaction, right? Ultra-virus transaction. If the company incurs losses, right? Shall we take down, right? Number 3, right? Answer to the question number 3. Right. Shall we mention like this, right? According to section 17 subsection 2, according to section 17 subsection 2 of the Companies Act, the Companies Act, all the transactions right? Within brackets, we can say including ultra-virus transactions, including UV transactions, all the transactions. Those transactions are valid and enforceable. Valid and enforceable. Then next slide we can say, however, ultra-virus transactions have two legal effects. religious effects, right? Next time we can say before engaging into ultraviolet transaction, before and after. Before engaging into ultraviolet transaction. Before engaging into ultraviolet transaction. Right? Then you can, like, mention, right? Before that, you can mention, before engaging into ultraviolet transaction, any shareholder or director, the shareholder or director can bring an action against the company by preventing the company from engaging in ultraviolet transaction. From engaging in ultraviolet transaction. Then next line, after, right? It's not after engaging into ultraviolet transaction. After engaging into UV transaction here, ultraviolet UV transaction. After engaging in ultraviolet transaction. After engaging into ultraviolet transaction. Right. So before that, we can say, right? If the company suffers any loss, by an ultraviolet transaction, right? Directors are personally responsible. Directors are personally responsible to compensate the company. Compensate the company. Right. Now, the part B of the second question, PQ, OPQ, private limited, has the following directors: managing director, executive, shadow, non-executive, tax consultant. Directors and Galle is the tax consultant of the company. Tax consultant. Explain the roles and types of directors in this company. Right. we have to first consider about the directors, managing director, executive director, shadow director, non-executive director. Right. First consider executive and non-executive. Right. Who are the executive directors? Yes. Executive directors. Explain the roles and types of directors in this company. Managing director, executive director, shadow director, non-executive director, and that's a tax consultant. Yes, tax consultant also there. Executive. What is the meaning of executive director? Yes. Executive director. Executive director. Non-executive. Executive, non-executive. Executive means member of the board of directors plus, right, employee or an officer of the company. Right? At the same time, he is an officer of the company. Employee, like director finance, a member of the board of directors as well as the accountant of the company. Director legal, a member of the board of directors as well as, or at the same time, is the company lawyer, right? Director legal. So member of the board of directors plus an employee of the company. That is executive. Non-executive means only a member of the board of directors. Right? Only member of the board of directors. He is not an employee. Non-executive. Managing director. Yes. Who is managing director? Managing director is an executive director who is appointed as the managing director by the board of directors. That is the definition given in the company's executive director appointed as the managing director by the board of directors. Therefore, he is the chairman of the board of directors. Right? Managing director. Shadow director. Right? He is not properly appointed to the board of directors. Right? He is not properly appointed to the board of directors, but he directs the board of directors from out. Right? He directs the board of directors from out. And the board of directors will comply with the directions given by the shadow director. The shadow director also the director. These are the types of directors you can identify. Directors. Then differentiate the consultant from the shadow director. Yes. How we can differentiate consultant from shadow director? Like shadow director and consultant, when we compare these two parties, consultant is a professional. He will consult the board of directors in his capacity as a professional, like a lawyer, right, or accountant. In his professional capacity, he will Right now, we are discussing about the difference between consultant and shadow director. Consultant, he is a professional, like a accountant, lawyer, professional. Executive director. Executive director again. Who is the executive director? Executive, not the executive, managing, shadow, shadow director. Executive director means the member of the board of directors plus an employee. Couple of other there. Right? At the same time, he is the right. He is an officer of the company. Member of the board of directors. At the same time, he is an officer of the company. Executive. Not the executive, only a member of the board of directors, not an employee, not an officer of the company, not an executive. Right? Managing director and executive director who is appointed as the managing director by the board of directors. Managing director is an executive director. Executive. Member plus officer. Appointed as the managing director by the board. Shadow director is not appointed to the board of directors, not properly appointed to the board of directors, but he directs the board of directors from out. That's why we named him as shadow director. But shadow क्या है? नहीं you cannot identify his name in the board of directors. Then consultant, differentiate consultant from shadow director. Right? Consultant is a professional. Right? He will advise the board of directors in his capacity as a professional, like a lawyer, accountant, a professional capacity. But shadow director may be a professional or a layman. Right? He is not to be a professional. That is the difference. Like discuss directors' duties in solvency and serious loss of capital. And what that is very important. What are the duties? What are the duties of the director? Insolvency and serious loss of capital. Insolvency. First one we can consider insolvency. We are putting insolvency. Duties of the director. Duties of the director in insolvency. What is the duty? Tell me. Insolvency. In insolvency, what is the duty cast on the director? To call, right? Immediately, right? Immediately, we can say promptly, right? Immediately, right? He must call a board meeting. That is the duty. Right? What is the meaning of insolvency? Somebody is right. What is the meaning of insolvency? Detective work. unable to pay its debts. Unable to pay its debts in its ordinary course of business. Working capital issue. Working capital. There is an issue in working capital. There is an issue in working capital. Unable to pay its debts. That is the meaning of insolvency. Right. Next one. Next slide we can say serious loss of capital. Serious loss of capital. Serious loss of capital. Yes. What is the meaning of serious loss of capital? Yes. Serious loss of capital. Right. 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 Within brackets, we can mention that serious loss of capital. Net assets of the company. Net assets of the company. Net assets of the company. Less than net assets of the company. Less than half of the stated capital. Half of the stated capital. Right? Or you can say, right? Or there is a accumulated loss in the company. Accumulated loss. There is an accumulated. There is an accumulated loss. There is a loss. So an accumulated loss. There is an accumulated loss in the company. That is the meaning of serious loss of capital. Then what is the duty? Duty is serious loss of capital. Yes. Within 20 working days. Within 20 working days. Within 20 working days, the director shall call an EG, extraordinary general meeting, an EG. To explain the financial situation to the shareholders. Okay. So, if there is a serious loss of capital, the duty of the director is to call an EG, extraordinary general meeting, within 20 working days. In order to explain the financial situation with if there is insolvency there, it means unable to pay debts in its ordinary course of business, then immediately, no time, promptly he must call directors meeting. Actually, here we are meeting call in order to decide whether the board of directors apply to court to liquidate the company or further continue to business of the company. In order to decide. And thereafter, I told you, if he fails to do so, he fails to call the board meeting, then as a result of company continues his business and liquidated, then the director is personally responsible to the credit. Is personally responsible to compensate the credit. Right? Because he defaults in his duty. Right? So that is the duty cost of the director. If there is a serious loss of capital, right? Always, right? Solvency means insolvent. Insolvency means unable to pay debts, right? Then serious loss of capital means accumulated loss in the company. Accumulated loss. Therefore, net assets, value of the net assets is right less than half of the stated capital. Accumulated loss. You can identify minus figure, right? In the reserves, minus. Right? So that's accumulated loss. And then within 20 working days, right, director must hold an EGM, extraordinary general meeting. General meeting means shareholders meeting. Right? In order to explain the financial situation to the shareholder. Right. So that's about the duties of the directors. You can mark the agreement. On 30th, we can hold the second assignment. 30th. Open the page. Okay. Now then, first thing I second again. I September 6th of September. Open book test. 6th of September, we can hold the second assignment open to place. And on 13th, right, we can hold the submit. The last week. 13th. Right. Right. This is question number 3. There was a structure around a structure. Right. Right. Before incorporating a C private limited promoter, this is Ranasim signed a contract with global traders to lease office space for 5 years. Later, this is Ranasim abandoned the idea of incorporating a promoter. This is Ranasim. Global traders now demands rent from the person. Right? Discuss the legal position of pre-incorporation contract under Common Law and Companies Act. Right? Pre-incorporation contracts under Common Law and Companies Act. Right? Before incorporating STBC private limited, its promoter signed a contract with global traders to lease office space for 5 years. Later, Anasigna abandoned the idea of incorporating the company. Global traders, the other party to the contract, now demands right from the person. Right. Actually, whether the promoter is personally responsible to pay the rent, that is the issue. Right. Now, what is the legal question of the pre-incorporation contracts under common law? Thereafter, we can consider the legal question under the Companies Act. Right. Under common law, right? Under common law, actually, we have discussed the case Hill versus Baxter. There is a case. According to that case, court held the company cannot ratify its pre-incorporation contract. Thereafter, therefore, after the company is incorporated, that company cannot ratify its pre-incorporation contract. That is under common law. According to the case law, common law means case laws. According to case laws, the company cannot ratify its pre-incorporation contract. But what happens with the Companies Act? What are the provisions introduced in the Companies Act? Yes. The Companies Act. It says, Section 23. Section 23 says that the company may ratify. That word is very important. May ratify its pre-incorporation contracts after ratification, valid and enforceable as company was the party to the contract at the beginning, telling them enforceable. However, when the promoter is engaging into pre-incorporation contract, he will give 2 warranties to the third party. What are the warranties? First one is company will incorporate in the near future, right? That is the one warranty given by the promoter to third party. And the second one is after incorporation, company will ratify the pre-incorporation contract. Company will ratify. Right? So therefore, that if the company is not incorporated, or after incorporation, if the company is not refused to ratify the pre-incorporation contract, then the third party can claim damages from the promoter on the basis of breach of warranty. So, breach of warranty, violation of a warranty. So on that ground, third party can recover damage. Right. So that is the situation. Under the common law and companies can. Right. First, we get considered the common law. Right. You know, clearly. Yes, there is. Right. According to common law, right? According to common law, according to the common law, the pre-incorporation contract cannot be ratified. Cannot be ratified. Right. Next time we can mention the case. The case is Galle versus Daxter. Example, Galle versus Daxter. Galle versus Daxter. That cannot be ratified. Right. Right. Next time we can say, however, according to the section 23 of the Companies Act, right? Section 23 of the Companies Act, after incorporation of the company, after incorporation of the company, incorporation of the company, that company may ratify, be ratified. Be ratified. It's pre-incorporation contract. It's pre-incorporation contracts. Right? Shall we underline be ratified? Be ratified. Therefore, the company can either ratify the contract or refuse to ratify. It is not compulsorily ratify the contract. Right? There is no direction given to the contract. You must ratify. Be ratified. Contract be ratified. It's free cooperation contract. Right? Then next time we can say, right, after application, the pre-cooperation contract, after application, the pre-cooperation contract is valid, is valid as the company was the party to the contract at the time of making of the contract. The time of making of the contract. The next slide, we can say, right? However, when a promoter, engaged into pre-cooperation contract, he would give 2 warranties to the third party. He would give 2 warranties to the third party. Number one, next time we can say number one, the company will incorporate in the near future. Company will incorporate in the near future. The second one is number two, is that number two, after incorporation, the company will ratify. Company will ratify the pre-incorporation contract. The company will ratify the pre-incorporation contract. Instead, we can say, therefore, if the company is not incorporated after the pre-incorporation contract, the third party can claim damages from the promoter on the basis of breach of warranty. Breach of warranty. On the basis of breach of warranty. Basis of breach of warranty. Right, so that is the situation in the legal position in the Companies Act. Right. Common law Act, right? Legal position under the common law and under the Companies Act. Right. So that is with regard to the pre-cooperation contract. Then write short notes on derivative action. What do you mean by derivative action? Position of the company secretary, solvency test and prospectus. Derivation, derivative action. Derivation action. Derivative action. Derivative is derived, right? The right is derived. Derived, right? The right is derived by the shareholder debate. Right? Yeah, this is under, we have discussed this under majority rule and minority protection. In order to protect the minority's interest, some rights given to the shareholders and directors. One is derivative action by being a shareholder or director of the company. Right? If the company is going to engage into a conduct which is violating the Companies Act articles, then they can bring an action in order to prevent the company from engaging into that illegal or right unlawful conduct and bring an action in order to prevent. That is like injunction, right? Injunction. Now, injunction is this is right file an action by seeking, right? By seeking an order to prevent someone from engaging into particular conduct. That is an injunction. Same meaning, right? But only thing is, right? By being the shareholder and directors, they can bring an action in order to prevent the company from engaging into illegal conduct. That is derivative action, right? I mean, derivative, that is the derivative action. Right? This is an action. This is an action filed by the shareholders or directors of the company. Shareholders or directors of the company. Right? To prevent the company from engaging into wrongful decisions. Wrongful decision. Wrongful decision. Next time we can say, right, by being directors and shareholders, right, by being the shareholders and directors, by being the shareholders and the directors, this right is given to them. This right is given to them. That's why we name it as legal. Right? By being shareholder and directors, this right is legal. Right? Right? Position of the secretary, company secretary. Okay. What is the legal position of this? Not legal. What is the position of the secretary? So which one we have mentioned? There are two cases we discuss. First case, it says secretary is beyond employee. He can do what he is told to do. And the second case, panorama development versus period. That case, OM is not a mere employee, right? He is the chief administrative officer of the company. Therefore, like the secretary has apparent authority, like to engage into activities which are purely administrative. That is the legal question, latest one, right? Apparently, the legal question, right? The secretary of the company, the secretary of the company, the secretary of the company is treated as, is treated as, is treated as, is treated as the chief administrative officer. Chief administrative officer of the company. Chief administrative officer of the company. It's like, therefore, he or she has an apparent authority. Apparent authority to engage into transactions which are purely administrative nature. Purely administrative nature. Purely administrative nature. Right? Example, right? It's like example. Purchasing stationery. Purchasing stationery. Hiring vehicles. Hiring vehicles. The one is recruiting employees. Recruiting employees. These are administrative transactions. Some activities he cannot do. What are they? we cannot engage in trade contracts. Trade contract. But next slide. However, following transactions are not treated as administrative. Following transactions are not treated as administrative transactions. Not treated as administrative transactions. Right? Number one, borrow money on behalf of the company. Borrow money. Another one, engage into trade contracts. Trade contracts. Trade contracts. Right. Another one is polling. General meeting. General meeting. On his own motion. His own motion. On his own motion. Right? On his own motion. Right? If the board of directors asks him to call, then he can call. On his cannot. Like we can watch the next one. Solvency test. What is the solvency test? Solvency test. Yes. Yes, there are two tests. We have to consider under the solvency test. So, company must meet two conditions. Right now, we are tackling for the solvency test. Right, number one, we have been first one is solvency test. Under that, first test is right. We have to consider working capital. We have to working capital. We have to working capital. Right. Dash. We have to right. According to the company side, says they have to check right whether the company right whether the company is able to pay its debts. Able to pay its debts in its ordinary course of business. Ordinary course of business. Right. Whether the company is able to pay its debts in its ordinary course of business. That is working capital. Number two. Right. Number two, we have to consider right reserves. Reserves. Right. Reserves. We have to check whether the company has reserves. Right. Within brackets, we can mention, right? Within brackets, we can say, right? The value of the total assets, the value of the total assets is, value of the total assets is greater than stated capital and liability. Stated capital and liability. So that is the meaning of reserve. Another one is the solvency testing is deductive, right? We have to consider two conditions, product value and income, right? Ultimately, right? The value of the total assets is greater than stated capital examination, right? We have to check whether company able to pay its debts in its total cost of business. Right? So working capital, good working capital, and we have to check reserves are there. Right? Prospectus. What is the lease? What are the prospectus? Yes. Simple. An indication, right, published by the public company by inviting the public to purchase the shares of the company. This is an advertisement for a circular published by a public company. Right? A public company. Inviting the public to purchase the shares. Purchase the shares of the company. Shares of the company. That is in about 2.5 marks. This is about the meetings, resolutions, right? Regarding that discussion is that goes through. Right? Is it there? ABC PLC is a listed company. Right? The last AGM was held on 31st of July 2022. Company के इधर दा सकते हो, तब तक भी तो कितना मिलेगा, हर जगह कल के दिन बाहर का कोई नहीं है, आपको प्राप्त में मगर नहीं था, right? So right, AGM was held on 31st of July 2021. The balance sheet date is 31st March each year. There are 5 shareholders in the company, and they are holding the voting rights. 50% XY, 20, 15, 10, and 5%. Distinguish the distinguish between an AGM and EGM. AGM is annual general meeting. It is once in each calendar year, right? This compulsory, right? We held by every type of company, right? And maximum period is mentioned 15 months, right? And not later than 6 months, right? The company defaults in holding its AGM, right? It can be bring it to the notice of the register of companies. That he can direct the company to hold the meeting. That is not, then company shall be guilty of an offense. Therefore, this is compulsory meeting. But EGM, extraordinary general meeting, that is, right, again, general meeting or shareholders meeting, but it is not compulsory. If the company unable, right, company has to make a decision, but company unable to wait until next AGM, right, because of the emergency, right, urgency, right, company may call EGMs, extraordinary general meeting, right. Then you don't want to call an AGM, not less than 15 working days notice to be given. EGM in a private company, 5 working days notice. Public company, 10 working days notice, right, to be given. Otherwise, we can identify. Then how can ABC limited more than 80 within less than 50 working days notice? 80, how company can hold AGM with less than 50 working days notice? So generally 50 working days notice to be given. Now the company is going to hold the AGM by less than 15 working days notice is given. After giving less than 15 working days notice, company is going to hold the AGM. Like how can we yes, how this company can hold this AGM like this way? Not hold an AGM, not less than 15 working days notice to be given. Now suppose the company is going to hold the AGM after giving 10 working days notice. How company can hold the AGM? With consent of all the shareholders. Right? If all the shareholders of the company right, give their consent to hold the meeting by short notice, that 15 working days notice, then it is right valid. It is valid. So that is the way. With consent of all the shareholders, right, they can hold the meeting with less than 15 working days notice. Right? Thereafter, date I will discuss it. Right? Then the company passes a special resolution at a short notice. How company can pass a special? What is how company can pass a special resolution? Two conditions to be fulfilled. Yes. Yes. Two conditions to be fulfilled by majority of what is the percentage? You want to pass a special resolution by majority of 75% of votes after giving not less than 15 working days. Two conditions. Now here the company is going to pass a special resolution at short notice. Right? It means less than 15 days notice given and call the meeting, and at the meeting the company is going to pass the special resolution. Then how company can propose and pass resolution as a special resolution by short notice, right? With consent of 85% of votes at the meeting, right? By majority of 85% of votes, right? This company can propose and pass the resolution as a special resolution, right? Now, generally 75% of votes after giving not less than 15 working days notice. If the company unable to give not less than 15 working days notice, right? Unable to give is company able to give only 10 working days notice. Then percentage will increase up to 85%. Because by majority of 85%, right? 85% of votes at the meeting, right? This resolution to be approved. Otherwise, the company cannot pass special resolution by short notice, right? That is right. Less than 15 working days notice. After giving less than 15 working days notice, company cannot pass special resolution. The regular resolution also we discuss later because we can apply that percentages that we have to discuss, right? Here the question is, can the ABC PLC sign a written resolution without shareholder B's consent? B means this person, right? He opposed to the resolution, did not give his consent to the resolution. So without having the consent of B, the question is, can this company sign a written resolution? That's the issue. Right. So we consider this thing, right? Right. With the yes, stop on the bit. Because managing director, we cannot compare. Managing director is an executive director. Member of the board of directors plus an office of the government. Executive director who is appointed as the managing director by the board of directors. Right? So managing director is properly appointed person. Properly appointed. But shadow director is not properly appointed to the board of directors. Properly appointed to the board of directors. His name is not right in the board of directors. But what happened? Right? He will direct the board of directors from out. Right? The board of directors will comply with the directions given by this person. Shadow. Shadow is actually his name is not mentioned in the list. Not properly appointed to the board of directors. Right? So, executive. Right. Or executive executive director is right a member of the board of directors plus an employee. Right? Not the executive. Only a member of the board of directors, not an employee. Right? And thereafter, managing director and the executive director who is appointed as the managing director by the board of directors. Executive director and chairperson, right? In order to lead the board of directors, right? So that is executive. Shadow director is not properly appointed to the board of directors. It is not there. But from outside, he is outside. From outside, he can give directions to board of directors. Board of directors. The board of directors comply with the directions given by this person. Shadow director. Then the third part is consultant. Consultant also, right? Almost similar to the shadow director. He's not with the board of directors. And he will, right? He will advise the board of directors. Then, consultant, right? Advise the board of directors and board of directors comply with the advices given by the consultant. The same, right? Things we can identify in relation to the shadow director and consultant. But consultant, always consultant is a profession. He directs the board of directors in his capacity as a profession. But shadow director, it may be a professional or a lay. Need not to be a professional. Need not to be a professional. Right? Shadow director. That's actually very right, difficult to identify who is shadow director and consultant. It's very difficult. Some cases, there are some responsibilities imposed on the director according to the corporation. Therefore, some are appointed as consultants, but actually they are directors. They have the same capacity as the directors. They are not personal. We can other things even someone from the power is a 80 kilometer, right? They get the appointment letter as consultant. Actually, they are doing the same part as the directors. Able to director responsibility is an appointment consultant. Same capacity. Very difficult to identify, but that is that. Yes. That is the way how we can identify shadow director and consultant.